Hi, this is Brian Ka with another video to help you pass the California Baby Bar Exam and the California Bar Exam. So we're going to continue doing another wills and trust question, and this is from July 2013, question 5. So let's look at the call of the question and see what they want us to write about. So here we have what rights, if any, do Bertha, Sam, Dot, and Cindy have in Ted's estate? So let's write those names down. Bertha, Sam, Dot, Bertha, Sam, Dot, Cindy. And the question is, what rights do these people have in Ted's estate? So let's assume that this is Ted's estate. So we have to try to figure out what can Bertha, Sam, Dot, and Cindy get from Ted's estate. And to do that, obviously, we're going to have to read further down the line and read the fact pattern and see where it takes us. So let's see. In 2000, Ted was married to Wilma, with whom he had a child, Cindy. Wilma had a young son, Sam, from a prior marriage. Ted typed a document entitled Will of Ted, then dated and signed it. Ted's will provided as follows: I give 10,000 to my stepson, I give 10,000 to my friend Dot, and I leave my share of all my community property to my wife. I leave the residue consisting of my separate property to my daughter, Cindy, and I hereby appoint Jane as executor of this will. Okay, so right away, they're telling us that Ted typed a document entitled Will of Ted. And right away, unless they're telling us whether this will was valid, we're going to have to see and go through the elements to see if this was in fact a valid will. So in order for us to do that, we have to go through the three-part test. One is whether Ted intended there to be a will. Number two, we have to look at capacity, right? And capacity is first, you have to be 18 and over. And second, you have to understand the nature of the bounty. Understand nature of bounty. Also, you must understand the nature of assets. And you have to know what you're doing, right? So, nature of actions. So basically, it comes down to whether Ted was or had a sound mind. So I would go through that. And third, a valid will has to have all the will formalities, correct? So formalities. Now, when we talk about formalities, remember that we have two types of wills: attested and holographic. Um, so here, it looks like Ted typed the document, right? So when it's typed, because holographic wills are handwritten, we have to analyze under whether this was a valid attested will. Now, for attested wills to be valid, we have to again have go through many elements. The first is whether um, it was signed and in writing. This is pretty complicated. I find that wills is generally very complicated, and I can see why some people, practice, estates, or they just practice wills. I don't think I'm gonna be one of them, but this is something that we're gonna have to do. Uh, just bulldoze through, even though it's not easy. Um, we have to master it, and we have no choice. So, even though I understand that this can be difficult, even for me, this is not easy. Let's try our best to go through this question. So, sign writing, right? It needs to be witnessed by two disinterested witnesses, meaning the witnesses can't be the beneficiary, meaning if the witness is Bertha, Sam, or Dot, or Cindy, they have to overcome the presumption that there was um, fraud, misrepresentation, or undue influence. So this is one of the requirements. Let's see, it needs to be signed by the testator in front of um, the witnesses. One thing that kind of tripped me was that um, in California, it needs to be signed when in front of the witnesses, but you can also acknowledge the signing in front of the witnesses. This was something that I wasn't aware of, but I had to go through this role many times to kind of get it. So make sure that acknowledgement of the sign in front of the witnesses is also valid. And lastly, it needs to be signed by the witnesses also, not just the testator, but the signing doesn't have to happen simultaneously as long as it happens before testator's death. So already, I mean, we have to know whether uh, to to know to have to see whether there is a valid will. We have to know intent, capacity, and formalities. But under capacity, we have to know that the nature of bounty, the testator has to know the nature of his actions or his assets, basically, whether he had a sound mind. Also, he had to be 18. He had to memorize all this. And this is why this gets kind of tough for me because there's so many parts to it. Now, intent and capacity alone isn't enough to establish a valid will. You also have to pass the formalities test. And under formalities, we're talking both attested and holographic. When it comes to holographic, I mean, this is easy because it just needs to be in writing, signed. But the writing has to have material terms handwritten by the testator. So that's kind of easy. You just have like two elements. But for a tested will, that's a little bit complicated because it needs to meet all these tests and this witnessing by two interested witnesses plus signed by the testator in front of the witnesses, acknowledge the or this the testator acknowledges the signing in front of them, and also it needs to be signed by the witnesses before testator's death. So let's just quickly look at the facts and see if we can pass all these tests here. So whether there was intent, Ted typed a document entitled Will of Ted, right? Even assuming that this was not a valid will, when you type something that says Will of Ted, that shows intent to create a valid will, right? On top of that, he dated and signed it. And the terms he wrote inside, I mean, we're going to get into capacity, but they're very detailed. So, using all these facts, I would establish that yes, there was intent to create a valid will. Now, as far as capacity goes, testator's age is not revealed in this fact pattern, but he was married twice, had kids. We got to assume that he was over 18, right? But that's not everything. Does he understand the nature of his bounty? You know, did he know who his son was, who his wife was? And here he wrote specifically saying, I give 10,000 to my stepson, give 10,000 to my friend Dot. I leave my share of all my community property to my wife. I leave the residue to Cindy, shows that he understood the nature of his bounty, right? Now, whether or not he understood the nature of his assets, he said, 10,000, 10,000, my share of all my community property to my wife. And he even mentions the residue consisting of my separate property to my daughter. So he was aware of what consisted as community property, that he had, this much money left in a separate property account. So he was aware of all that. Now, was he aware of his actions? Most likely. If you read further, the second paragraph, it says that Ted showed his signature on the document to Jane and Dot and said, "This is my signature on my will. Would you both be witnesses?" Jane signed her name. Dot was about to sign when her cell phone rang, alerting her to an emergency, and she left immediately. The next day, Ted saw Dot. He had his will with him and asked Dot to sign. She did. So all this stuff adds up to whether he understood the nature of his actions. Nothing here suggests that he was delusional or his mind was sick, right? He it doesn't reveal anything about his mental defect. So using all those facts, I would say that he passes the capacity test. Now, the second paragraph which I just read is all about whether there was a valid attested will formalities. And they're giving you all these facts so that you could go through every single one of these and see if it passes these elements. So it was signed and was in writing, right? Because Ted typed a document entitled Will of Ted, dated and signed. No problem. Witnessed by two disinterested witnesses. So, who are the witnesses? Jane and Dot. Now, we have an issue here because Dot is one of the beneficiaries. So, this element, witnessed by two disinterested witnesses, doesn't pass the test for now, right? But remember, if there is a codicil or a subsequent will, and if that will or codicil is valid, then it cures the defect. So rather than saying, okay, this is not a valid will, we just cross it out, assume that for now it's not okay, but later on it could be revived and could cure this defect. So let's just wait and see what happens. So was it signed by the testator in front of the witnesses, or was it acknowledged, or did the testator acknowledge the signing in front of the witnesses? Now, here it says Ted showed his signature on the document to Jane and Dot, right? And said, "This is my signature on my will. Would you both be witnesses?" So, yes, even though it wasn't signed by the testator in front of the witnesses, it was acknowledged. So, this passes the third test, right? Again, this acknowledgement part wasn't clear to me. I thought it was just uh, signing that was allowed in front of the witnesses, but make sure to note that acknowledgement of the signing in front of the witnesses is also valid, right? Now, was the will signed by the witnesses before testator's death? Here it says Jane signed. Dot didn't sign because she left after her cell phone rang. The next day, Ted saw Dot. He had his will with him and asked Dot to sign, and she did. Now, if you didn't understand that the signing by witnesses doesn't have to happen simultaneously, then this may trip you out. However, the rule is that as long as the witnesses sign before testator's death, then the signing requirement by the witnesses is valid. So Jane and Dot both signed, and this satisfy the fourth element. So far everything is okay, but because it wasn't witnessed by two disinterested witnesses, this is not a valid will. Now let's move on and see what happens. So in 2010, Wilma died, leaving her entire estate to Ted, and Ted married Bertha. Okay. And in 2012, Ted wrote in his own hand, "I am married to Bertha, and all references to my wife in my will are to Bertha." He dated and signed the document. Okay. So the first person here, we kind of figured out what who she is, and we're gonna have to figure out what she gets. Now, the facts tell us that this was his second wife, right? And in 2012, he wrote in his own hand. So they're pointing or leading us to analyze whether this was a holographic codicil or holographic will. But let's see. "I am married to Bertha, and all references to my wife in my will are to Bertha." He dated and signed the document. Okay, so it looks like this wasn't a will because the facts don't tell us that he wrote a will in his own hand. It looks like a holographic codicil or codicil, right? It's basically adding a clause after a will. And what happens is first, we have to analyze whether this was in fact a valid codicil. And in order for this to be valid, it needs to be, it says, wrote in his own hand, right? So signed and in writing, right? Writing has to be handwritten. So here, "I am married to Bertha, and all references to my wife in my will are to Bertha." Okay, so it was in writing, and it was also handwritten. if it was holographic will, then all the material terms also need to be handwritten. But this was likely a codicil. As long as it was signed and in writing, and it was handwritten, passes the codicil holographic codicil test. And since this passes both tests, this 2012 codicil becomes valid as long as it passes the uh, will validity test. So signed in writing and handwritten, but it needs to satisfy um, this valid will requirement for a holographic will, which it did, but it needs to also satisfy intent plus capacity, right? So I would go through intent element, whether this uh, in 2012, whether Ted had the intent to create this holographic codicil. I would also go through capacity. I'm not going to rewrite the roles, but I would say that most likely he understood his nature of his bounty, nature of his assets, nature of his actions, had a sound mind. So intent and capacity element, as well as formalities, since this was not a tested codicil, it was a holographic codicil. The elements are a lot easier, so it also um, passes the formalities requirement, right? So if this 2012 um, holographic codicil is valid, what happens is that this replaces the 2000. This was a 2000 will, which was defective due to having two interested or one interested witness instead of having two disinterested witnesses. Um, it cures this defect, and what would happen is, since this was valid, uh, it would be integrated into this defective uh, will and read together as one will, right? So, as far as Bertha goes, after doing all this since 2012 holographic codicil was valid and read together with um, the will from 2000, because of incorporation by reference, and there's got to be elements under that. Um, will existed at the time, right? Was in writing, and also um, references the will and intent, right? So I would go through incorporation by reference under Bertha, and even though we already talked about both the new codicil and the defective will um, being integrated and read together, I would also talk about incorporation by reference and go through these elements. The 2000 will existed when this holographic codicil was created. It was indeed in writing, and this 2012 codicil does reference the 2000 will, because it says I'm married to Bertha, and all my references to my wife in my will are to Bertha. All my references is leading us to think about this 2000 will, and his intent to replace is clear here. So what we have in the end is, um, after incorporating the 2012 codicil, integrating it with 2000, um, what does Bertha end up with? Well, Ted had a total of 600,000, right? Now 300,000 was community property, CP, and 300,000 was a separate property. Now, when you go back to this 2000 will, he said that he wanted to leave all his community property to his wife. So that means that, um, this $300,000 CP is going to Bertha, right? So, what rights does Bertha have in Ted's estate? Bertha gets $300,000 CP, right? It's a lot of money, so good for Bertha. Now, Sam, when you go back to, um, this 2000 will, it says, um, 10,000 to my stepson, right? So Sam is his stepson. So 10,000, and that 10,000 is going to come from his separate property, which leaves him now 290,000, right? Now for Dot, he, in his 2000 will, he said $10,000 to Dot, right? Now, this is important because, um, she was also a interested witness, but the facts don't tell us whether there was some kind of, undue influence, any kind of misrepresentation. So, most likely, without these facts, um, Dot will most likely end up getting this $10,000, right? But she needs to overcome the presumption that she was, in fact, an interested witness, and it would be up to her to rebut that, right? But chances are, most likely, she'll be able to rebut that presumption that, she was also an interested witness. So she'll probably convince the court that she does deserve this 10,000, and she'll probably end up getting it. Lastly, Cindy, um, the 2000 will said that he leaves the residue consisting all my separate property to my daughter Cindy, right? So after 10,000 to Dot, he's going to end up with 280,000, and according to his 2000 will, the 280,000 goes to Cindy. So we've distributed everything. This 300 this 300,000 to Bertha, So she's gonna end up with the house. $10,000 from 300,000 to Sam. 10,000 from 290,000. Uh, so after Sam becomes 290, after Dot it becomes 280, and since in his 2000 will he wanted to distribute all his residue to Cindy, Cindy ends up getting $280,000, and that answers what rights, if any, do Bertha, Sam, Dot, Cindy have in Ted's estate? And they do have rights, and they will end up getting these figures in the end. So that was not easy, I gotta admit. And I personally don't like to do these because, again, I'm not looking to practice in this area. I'm not interested, you know, not even a little bit in doing, estates, wills, and trusts. But, it's something that we're going to have to learn and master in order for us to pass the bar exam. So I hope that this was another helpful, useful video for you. And if you're struggling with this particular essay, I hope that you watching me struggle to remember all these rules of law motivates you, that you're not the only one that's struggling with this question. It's other people too. So I hope that this video was very helpful, and want to thank you for watching another video, and I'll see you next time.